Good morning, everyone, and welcome to another episode of PLA. Bruno's here with me. Morning, Bruno. How are you?
I'm well, how are you?
Good. Let's hop straight into the questions today.
Sure.
And we have received a question with regards to month-to-month lease agreements. And specifically, the question relates to when a fixed term agreement comes to an end. At what point does the lease agreement become a month-to-month agreement? Or are there other ways that lease agreements can be formed as month-to-month agreements?
So the question on whether a tenant can simply leave a property when the tenant is bound by a month-to-month lease agreement, or when the tenant is bound to stay there for even longer than month-to-month, has actually caused confusion. And interestingly enough, the experts in the industry don't quite understand where this confusion came from. So I'm just going to deep dive into it a little bit and just explain the different perceptions that the tenants have versus what landlords have versus what property practitioners and legal practitioners have when it comes to this question. Now, remember, very, very basic concept. A lease agreement for a fixed term period runs from one date to another date. So as an example, if from the 1st of January to the 31st of December, a person enters into a lease agreement, it runs for the entire period of time. So I've had tenants that approach landlords to say, no, but I'm canceling the lease. I'm giving notice. And this was prior to the CPA, mind you, where there was this assumption or this understanding by tenants that they can simply give 1 month notice and they can leave any lease whatsoever. I've even seen lease agreements that provide for a fixed term period, and yet within this period still allow for notice to be given. And again, this was prior to the CPA. So unfortunately, there was this misinformation or confusion in the industry where tenants were allowed to give some minimum notice and they were allowed to vacate the property. Then the Consumer Protection Act came in, and the Consumer Protection Act actually made it permissible. So the tenant was allowed to give notice. So even though they're bound to 1 year, 1st of January to 31st of December as an example, even though they were bound to pay rent for that entire year, the Consumer Protection Act gave them the right to terminate the lease agreement, the fixed term lease agreement, early. Right? Now, that was a game changer because now it was in law. They were allowed to cancel the lease agreement early. The problem is that the duty or responsibility to pay a reasonable cancellation penalty by the tenant isn't always understood. So now we've got tenants giving this notice saying, but I'm entitled to give this notice. And a lot of lease agreements actually even provide for this 30-day notice. But this reasonable cancellation penalty is forgotten. People don't understand how this is calculated, how it's applied. The TPN lease, for example, at least specifies that there would be a consideration of what this penalty would be, but it would be a minimum of at least 1 month to a maximum of, say, 2 months or 3 months, right? Now, in industry, we tend to see that 1 month to 2 months seems to be the normal practice when it comes to this the cancellation penalty. But the reality is a tenant doesn't understand how this penalty works. So again, we're receiving notices by tenants that they're leaving or terminating these fixed term lease agreements, not understanding that in the past, the reason why this penalty was introduced is because a landlord is left without a tenant. So 30 days is often not long enough to fill a unit with a new tenant. So some damages in the past before the CPA were going to be suffered by a landlord, and the landlord was entitled to charge the rent up until the end of the agreement, alternatively, the rent up until the point where they acquired a new tenant. Right? This reasonable cancellation penalty somewhat touches on these landlord rights to still do so. And by virtue of that, one does need to calculate with these concepts in mind. So to touch on the last aspect, when can a tenant simply leave a property and not have to and not give any notice at all? again, going old school, if on the 31st of December your lease has expired, then the tenant is actually supposed to leave the property. He's not supposed to stay on the property, and there's nothing requires him to do anything prior to that. The lease is expired. It's expired. So there's this, again, now this is a landlord misconception of, but leases simply continue on a month-to-month basis. There's some lease agreements that require the tenant to give 30 days notice prior to the expiration, failing which the lease will continue on a month-to-month basis, right? We are forgetting one primary principle. 31st of December, lease expires, lease expires. Because of that, anything past the 31st of December is considered to be some kind of renewal or auto-renewal, which is normally an agreement between the parties. And again comes the Consumer Protection Act saying that if an agreement is about to auto-renew, the landlord must, not the landlord, the supplier rather, must inform the consumer of this auto-renewal. So imagine your cell phone contracts, or you buy something from Google Play Store and every year it keeps renewing and charging you 2,000 Rand every year. Now you as a consumer are going to forget that on the 1st of April 2026, this auto renewal is going to kick in. You're going to pay for this app again, whether you're using it or not. So what the Consumer Protection Act required was that now the supplier has to inform the consumer that this renewal is going to come up, that the expiration is going to come up, and that the renewal will be processed. Same thing with landlords. If you want your tenant to stay on a month-to-month basis, in those instances, you have to inform them of the expiration. And then in those situations, if the tenant is obliged to notify you that he's not going to renew, and he needs to give you 30 days notice that he's not going to renew, then that will apply. Now, a month-to-month agreement will kick in, and this will kick in, but it's not necessarily an auto-renewal in a normal sense, if the tenant stays on the property. So if on the 31st of December, the tenant does not vacate and stays on the property, then yes, the auto-renewal kicks in. We don't need to worry about the CPA. It's totally protected. Why? Because the legislation provides for there to be an extension of the agreement on a month-to-month basis in the circumstances where a tenant did not leave the property, and that is permissible. But short of the tenant staying on the property, if the landlord did not give notice, then unfortunately the tenant is allowed to pack up and leave, and the tenant and the landlord is left without a tenant on that property, not being aware that this tenant had any intention of leaving. So best advice I can give, Consumer Protection Act, give that 40 to 80 day business notice to landlord. Please inform the tenant of the expiration, because this will at least entitle you then under the TP and lease agreement to receive a response from the tenant to say that they do not intend renewing the lease, which gives you time to market that property. Very, very important.
Perfect. Thank you for that.